May I first of all say a very good afternoon to everyone. It's indeed a pleasure for us to be able to have this meeting, and we are in the presence of very distinguished sons of the soil. So a very good afternoon, and maybe Kurasha, I'll call on you first of all for us to check the credentials of all the delegates, and so that we can know exactly who's present, and we can then move. Over to you, Kurasha.
Thank you very much, Chair, and good afternoon, honorable members. Chair, I wish to confirm that the chairperson, Seychelles, Angola, vice chairperson, Botswana, a new member, Honorable Lisedi, DRC, Honorable Balamange, Eswatini, Honorable Maulala, Lesotho, Honorable Maimani, Malawi, Honorable Belekanyama, Mauritius, Honorable Ito, a new member, and Zimbabwe, Honorable Ndiweni, are in the meeting. The Parliament of Namibia, the Parliament of Tanzania, currently, the Parliament of Tanzania is currently dissolved, and the Parliament of Namibia is yet to nominate. And on account of that, Chair, we constitute a quorum to be able to proceed with the meeting.
Okay, thank you very much, Kurasha. So allow me to welcome the two new members. Honorable Lesedi from Botswana, welcome to this forum, and also Honorable Ito from Mauritius. It's always good when you have other people who speak the same Creole. Alors, bienvenue, Honorable Ito. Unfortunately, the other new member from Mozambique is not joining us today. So anyway, we do have a quorum. But Kurasha, I just spoke to Honorable Darren Bergman from South Africa. You didn't mention him in the...
Chair, my apologies. My eyes ran from the new member from Mauritius and skipped Honorable Darren Bergman. My apologies. He's in the house. Sure.
He is in the house. Sure. So 1, 2, 3, 4, 5, 6, 7, 8, 9. Oh, that's a very good. That's a very good number we have. We have nine members. Okay, so that's okay. We'll just go to the next item, which is adoption of the agenda. This has been circulated, and we haven't received any other comments, so we take it that this agenda is adopted. Okay.
Chair, we will need a mover and a seconder to agree with the proposal.
Okay. Anyone in particular who would like to second the proposal? Okay.
I second.
You second. It'll be. Oh, Josefina. So good to see you.
How are you?
Yeah. Okay, good.
I'm seconding.
Okay, so the agenda is seconded by the vice chair, Josefina Daakite from Angola, and okay, again, Kurasha, lead us.
We proceed to the next item, Chair.
Okay, and the next item is, of course, the welcoming remarks from myself as the chair.
Mm-hmm.
So, honorable members of SADC PF Standing Committee, on democratization, governance, and human rights. And here I'd like to welcome especially the Vice Chair, Honorable Josefina, Secretary General of the SADC-PF, Ms. Boemo Segoma, the Committee Secretary, my good friend, Mr. Kurasha, who is also the Manager for Democracy and Governance and Parliamentary Business Focal Person, and other staff from the SADC-PF Secretariat. Our distinguished resource persons, Dr. Victor Shale, Justice Ki Dingake, Dr. Webster Zambara, and Ms. Anna Moyo. Representatives of partner organizations, including Dr. Adani from GIZ, Ms. Hilda Modisani from EF SADC, Mr. Stanley Nyamanhindi from SADC Lawyers Association, and the UN family. Representatives of civil society organizations, representatives of media organizations, ladies and gentlemen. I welcome you to this committee session, which is taking place ahead of the 47th plenary assembly session. We are meeting indeed during very extraordinary circumstances, when the entire world has been in lockdown since March in a bid to contain COVID-19 pandemic. This explains why we are meeting via Zoom instead of the usual face-to-face meetings. On behalf of the committee, and indeed on my own behalf, I wish to commend rather the Secretariat for putting in place the arrangements to ensure that we are still able to meet virtually. For us as parliamentarians, times of crisis are critical moments when we rise and assume a critical role in the governance of our countries. Citizens look to us as their elected representatives to make sure that their voices are heard and reflected in decision-making and policy implementation. Through their representation, lawmaking and oversight functions, parliaments are duty-bound to make sure that executive actions during the COVID-19 pandemic remain within the limits of the national constitutions and international commitments. Whatever mode of lockdown our individual countries are implementing, parliaments must ensure that democracy is not locked down. We still need to promote and protect human rights, especially for the poor and economically vulnerable, whose conditions have been worsened by the pandemic. Parliaments also need to ensure that there is a balance between measures for health and safety on one hand and the protections of fundamental human rights on the other. In view of the above, SADC-PF, through our standing committee, remains resolute to ensure that the SADC region continues to ensure that measures to protect people from the pandemic do not negatively affect the human rights, and that member states maintain the gains the region has made towards strengthening of electoral democracy. This is in line with the objectives of SADC-PF as set forth in Article 6C of the SADC-PF's constitution, which enjoins the institution, open inverted commas, to promote the principles of human rights, democracy, peace and security, regional integration, human and social development, economic governance, and gender equality through collective responsibility within the SADC region, end of quote. As we focus over the next 2 days on promoting electoral and transitional justice through accelerated implementation of the SADC model law on elections, it is very important that we remind each other of the work that SADC-PF has done in the last 2 decades in promoting democracy, governance, and human rights in general, and democratic elections in particular. SADC-PF has successfully mainstreamed the role of parliamentarians in promoting democratic elections since 1999, when it started deploying parliamentarians to observe elections in SADC member states. We have leveraged the unique role of parliamentarians as not only the products of elections, but more fundamentally as critical players in implementing legislative reforms and ratifying regional and international election instruments to facilitate their incorporation into domestic laws and policy. SADC-PF pioneered the development of the normative framework for democratic elections in the SADC region by first of all adopting the very first election instrument in the SADC region and on the entire African continent in 2001, the norms and standards for election in the SADC region. The forum also developed a compendium of all regional and international election obligations applicable to SADC countries titled Benchmarks for Assessing Democratic Elections in Southern Africa in 2013. Inspired by the need for continuous review of the legal frameworks on elections for member states and their alignment with regional and international electoral principles and obligations, the SADC-PF 44th Plenary Assembly on 4th December 2018 adopted the SADC Model Law on Elections in Maputo, Mozambique. The Model Law serves to assist member states in domesticating the principles, guidelines, and obligations stipulated in the revised SADC principles and guidelines governing democratic elections. And this, as you remember, was adopted by the Ministerial Committee of the SADC organ on Politics, Defense, and Security Affairs on 20th July 2015 in Pretoria, South Africa. Honorable members and distinguished participants, while regular elections are largely a given across the SADC region, it is important to note that it is the efficacy of election rather than their regularity which matters in terms of adding value to the democratization process. Even before the advent of COVID-19 related disruptions on the elections, the SADC region was already facing recurrent and emerging electoral challenges which are undermining the integrity and credibility of elections. I need not remind you that Malawi has just concluded a presidential election rerun following the nullification of the 2019 election by the Constitutional Court, citing massive irregularities. Talking about the Malawi elections, allow me the opportunity to congratulate on behalf of SADC-PF and the committee, the warm heart of Africa for a successful election and for the peaceful changeover of power. Congratulations. It is incumbent upon all of us to recognize the fact that building democracy is a complex process with many challenges, and the holding of credible elections is just but a starting point. Often, elections become a victim of the broad democratic deficit, and this compromises the integrity of elections. When the integrity of elections is compromised, it goes without saying that legitimacy of democracy is also compromised with undesirable ramifications. As we gather during this meeting, our focus should be on how SADC-PF and national parliaments, working collaboratively with other stakeholders, can assist the region to overcome the various electoral challenges that are faced by the member states individually and collectively, so that SADC can move towards democratic consolidation. It goes without saying that democratic consolidation requires not just the efforts of parliaments, but also the support of other key state and non-state actors, including governments, EMBs, political parties, media, civil society, business, labor, and these are just some of the key elements, among others. SADC-PF constitutes a critical regional mechanism for stakeholders to engage on these critical matters related to electoral justice and transitional justice, and find local, vibrant solutions. This meeting, therefore, could not have come at a better time. Honorable members and distinguished delegates, allow me as I conclude to thank our partners who have continued to collaborate with the committee in the delivery of its mandate. In this regard, I wish to sincerely thank our resource persons who are going to make presentations as they unpack the two issues of electoral and transitional justice in the context of the domestication of the SADC model law on elections. In addition, I wish to express the committee's sincere appreciation to GIZ and the Austrian Development Agency, ADA, for the financial support. We are indeed very grateful. It is now my honor to declare this meeting of the Standing Committee officially open. I thank you. Okay, so I thank you. So we now move to the consideration of the minutes from the previous meeting held at Southern Sun Hotel in Joburg, South Africa, on 2nd November 2019. And we had asked members to send in their comments. So we will not actually be going through the minutes if this is acceptable by all. And I think it will be best for us to go straight away to the two presentations so that we get into the meat of our meeting. And therefore, I would like to invite our distinguished Dr. Victor Chalet from the Shellstone Elections and Governance Consultants, who will address us on trends in electoral justice in Southern Africa, unpacking of the SADC model law on elections. Dr. Chalet, it's always a pleasure to welcome you, because you always give us the best and we always learn so much from your presentation. So over to you, my good friend, for your presentation.
Thank you, Chair. Honorable Ram Kalawan. May I say hello to the honorable members in attendance today, and also greetings to my fellow panelists. Greetings from Johannesburg. I'm sitting in my hiding place from the COVID-19. I hope I'm firing from the right place. Thank you, Chair. Indeed, as you have, and thank you very much for the opening remarks. As you have indicated, I will be making my contribution with regards to electoral justice, just doing an environment scanning of what obtains in the region. Now, Chair, by way of an introduction, maybe I can just point out that, as we all are aware, and indeed taking a leaf from your remarks, Chairperson, with your permission, the reality is that the nature of electoral contests in the region, and indeed in the entire continent, has become highly competitive, and this has often been followed by disputes. This is now something that is quite established, and it affects all of us on the continent. Now, these disputes that often follow elections arise, one, based on the different interpretations of the rules of the game. Sometimes they arise out of perceptions, real or perceived understanding or perceptions regarding a violation of the rules of the game. But we also have observed in the SADC region, and indeed elsewhere on the continent, that some of these disputes can be deliberately meant to derail the electoral process. We have seen political actors, for various reasons, inciting unrests during the electoral process because they do not want to see that process brought to its logical finality. Now, I would like to borrow from an international idea of what then electoral justice is, because I think they really have captured it so well. So if you look at the International Handbook on Electoral Justice, they define electoral justice as the means and mechanisms that are available in a country, local community, or regional or even international level for ensuring that in each election procedure, decision related to the electoral processes and all aspects of the electoral cycle are in compliance with the legal framework. It also says that such mechanisms ensure and restore the electoral rights. They also give people electoral rights or rather recourse in the event that there have been violations of the electoral process. And so such mechanisms ensure that people can be heard. They have avenues for laying complaints with regards to the electoral process. Generally, the electoral justice comprises of the formal and the informal components. I know that shortly there is going to be a presentation by Justice Dingake on Malawi as a case study, and that's what we're talking about, part of the formal aspect of electoral process. Now, in terms of what I'm supposed to speak about this afternoon, Chair, in terms of trends, I would like to address this question in terms of three areas. So I will say something regarding the institutional arrangements. I will also touch on the timelines, issues around access, and also the alternative dispute resolution. So if you look at the institutional arrangements, you'll see that the courts are generally designated or identified as the formal places for election dispute resolution. I'm talking about electoral justice, and I'm now talking about election dispute resolution. So maybe just for clarity, it's because electoral justice, as far as I understand it, is basically part of the broader election dispute resolution architecture. Therefore, the courts of law have in the SADC region the places to go for dealing with any electoral disputes. Now, results in the SADC region in terms of the performance of the courts of law in this regard is a mixed bag. Because when you look at some of our countries, you'll find that the courts of law have done relatively well in terms of attending to electoral disputes with impartiality. And also dealing with the electoral matters on time. And Chairperson, you just referred to the just ended successful elections in Malawi. I see my brother Semi is in attendance, and indeed we do echo your sentiments and congratulating them. So what we saw happening in Malawi, of course, this was not the first time, because again, we had a more or less similar reversal of an electoral outcome in Kenya that I believe my brother Justice Ngake may touch on. But we've also seen that the courts of law, or rather some of the countries, have also provided requisite infrastructure and resources, including setting up of the special electoral courts and magistracies. On the other hand, a look at the SADC region shows that some countries are seriously challenged when it comes to electoral justice. And high on the list of their challenges, in my observation, is the partisan manner in which some of our judiciaries are dealing with the electoral dispute. In South Africa, in recent times, there is now a notion or a phenomenon of state capture that has been topical. And so when you look at electoral justice, you can also safely argue that the judiciaries or the judiciary in some of the SADC member states is equally captured. And therefore, they have a difficulty when it comes to how they then, administer justice in as far as election disputes are concerned. But the other thing, which is a reality of our region and indeed the continent, is the inadequate human and financial resources that are at our disposals to deal with the electoral cases. Because as I said when I started, electoral contests are throat-cutting contests. In fact, some would say elections have become in the region and on the continent a war by other means. It follows, therefore, that there is going to be a lot of disputes. And I always pity people who work for the electoral commissions because, to use the words of my brother, a former chairperson of the Kenya Electoral Commission, Isaac Hassan, he says to serve in an electoral commission nowadays is almost like being an endangered species because you are on the receiving end. So under such circumstances, you find that electoral commissions and indeed our courts of law are expected to deliver more with less, which is quite difficult. Now, the third point is the limited timelines within which the cases are to be addressed. And I think I stand to be corrected by the legal minds here, but I think this is also an error in the legal framework design, where you find that the designers of the various legal instruments have not properly thought through in terms of the processes and the times required to deal with some of these things. And I will come back to the point regarding the partnerships or lack of it between the engineering of the legal framework and the EMB fraternity. Now, you also find in our SADC region a variation of the court system where in addition to the courts of law, we have the election management bodies also in some cases being given the responsibility to administer justice on electoral matters. It may sound a bit contradictory, but it actually does happen, where you find that some of the EMBs have legal powers to settle certain types of election disputes, or they are mandated to create certain structures that can also deal with disputes. I think one of the good cases there is what is called the Electoral Tribunal that you find, for instance, in the Kingdom of Lesotho, because it is not necessarily an organ of the judicial system per se, but it is an administrative kind of a structure within the Electoral Commission. Now, in terms of the timelines, Chairperson, you find that one of the major problems facing our continent, or rather region, is that it often takes too long for electoral disputes to be addressed. In fact, there are cases in many of our countries where you find that disputes that were lodged soon after the election, and some of them with the hope that maybe there could be some redress of sorts for that election. You find that such disputes end up being addressed on the eve of the next election, which then defeats the whole purpose. And this has led to a ripple effect as one of the triggers of election-related disputes in the SADC region and the continent. The inconclusive electoral processes, the unfinished or unresolved electoral disputes that then overflow into the next election cycle as a result of the weakness in the timing of dealing with electoral disputes. Now, the other issue that I want to touch on, which is a part of the problems in the SADC region, has to do with access to electoral justice. You find that in some countries, the legal framework does provide for a recourse that if electoral stakeholders are aggrieved, they have to follow certain things. But in reality, you find that that is almost impossible. So the issue of people not being able to access the electoral justice has, in many of our SADC countries, created challenges. You find that sometimes there's just too many procedures that at the end of the day stifle citizens' efforts to lodge complaints. So the bureaucratic maze involved in the filing of electoral dispute complaints makes access to electoral justice almost impossible. And sometimes it is because even though stated in the law that people can follow certain procedures, as I said earlier, you find that this is complicated by the fact that you basically are dealing with a captured judiciary. Now, the other point that I wanted to touch on is the alternative dispute resolution. This is part of the broader election dispute resolution architecture. I have spoken about electoral justice comprising of two components, broadly speaking, which is the formal and the informal. And so the alternative dispute resolution forms part of the informal component of electoral justice. Because it is informal, alternative dispute resolution allows all parties involved in a dispute to voluntarily settle the electoral related dispute. So you find that almost all our SADC countries have adopted an alternative dispute resolution mechanism of one type or the other. The difference becomes maybe in terms of the guidelines for the operations of such a structure, but majority of these structures are often referred to as party liaison committees. In some countries, they are called multi-party liaison committees. And when you look at the makeup of this, in some countries like South Africa, Zimbabwe, you'll find that these are structures that are made up of political party representatives, and they interface with the Electoral Commission. In other countries, including Malawi and Lesotho, you'll find that some of those, or rather these structures, also include civil society organizations. But the importance of these structures is that they allow for stakeholders to deal with their disputes without having to go through the formal court system, which, as I said, in some countries works well, in some countries does not work well because of the couple of challenges that I have highlighted. Now, having said this, Chair, and mindful of the time, I would like to quickly then tie what I have just said to the SADC model law on elections. So basically just emphasizing the nexus between the SADC law and electoral justice.
A lei modelo com a justiça eleitoral.
As you have said, Chairperson,
Como teria dito,
law on elections addresses the link between
eleitoral.
implementation, rather between policy and implementation at the regional level. So the SADC model law is meant to facilitate the adoption of the SADC principles and guidelines governing democratic elections. But most importantly is that electoral justice is embedded within the SADC model law. So the electoral justice, transitional justice, all those are quite enshrined within the SADC model law. This is why this law is so important. When you look at part 2 of the SADC model law, especially sections 5 that talks about the rule of law, and section 6 that speaks to universal adult suffrage, and section 16 that deals with the equality before the law, all those are the ingredients that serve to deliver credible electoral process. Those are sections that advocate for the delivery of justice, compliance with the electoral framework, and opening up or rather facilitating the lodging of complaints as and when they may arise in the electoral process. But the section of the electoral law that, to me, speaks directly to the subject of electoral justice is part 23. My goodness, I hope I got my Roman numerals correctly. But this is sections 89 to section 94. Because if you look at section 89, it speaks specifically about, in fact, the entire section of the, or rather part of the SADC model law speaks to election dispute resolution. So section 89 of that then speaks specifically to the election dispute mechanisms that, and basically says, what is it that member states are expected to do in regard to resolving election dispute resolution? They also, that section also speaks about the alternative dispute resolution that I've just spoken about. It also deals with the judicial mechanisms. It also brings into the picture the phenomenon of election tribunal and also electoral court, because I need to just mention that in developing the model law, SADC Parliamentary Forum was quite alive to the reality that the region has different circumstances, has different histories, has different economic conditions, has different legal, legal dispensations, and therefore it can't be one size fits all. So that sections, or rather those sections 89 to 94, introduce the various mechanisms that can be applied in delivering electoral justice. And it also, they also talk about the right to effective remedy before the electoral courts. So in conclusion, Chair, as I have said, electoral justice is about mechanisms at our disposal to ensure that the electoral process is conducted in accordance with the law, that where any one of the key actors is found offside, there is a mechanism to deal with the grievances that arise in that process. Because once that happens, we can then be sure that we will have political stability. Elections in our region will therefore serve as a means to an end, which is economic development, than what currently obtains, where elections are almost like an end in and of themselves, because part of the election-related violence that we have experienced in some of our member states, and I keep on saying some of your member states, Chair, with your permission, I'm addressing my leaders, the honorable members of parliament. So I have tried to avoid naming which countries have which, but they all are aware of what obtains in our region. I respectfully opted to not make examples with the different countries, but what I have said so far applies to the different countries, and each one of the participants can relate to some of these things. But just to conclude, then 2 or 3 more points, Chair, to say that electoral justice, in my view, requires the presence of the formal and informal ingredients of the electoral dispute resolution architecture, as I've said. So we cannot have electoral justice if there is formal and there's no informal, because again, that flexibility is required depending on the political environment in the country. Trends in our region have shown that there has been a rise in the judicial interventions. There's no doubt about that. We now know it's well-established trend that electoral disputes, as I said in the beginning, are dealt with through the court system. But of course, the results of such interventions have proven tricky in some cases, while in others, they have actually served the purpose. Now, in my view, one would therefore conclude that the engineering of the electoral justice system has to be cognizant of the peculiarities of the concerned country and be mindful of the regional dynamics. Lastly, Chair, I would submit that the judiciary and the judicial officers can deliver optimally on electoral justice if they are capacitated on their understanding of the electoral laws and ability to dispose of the election dispute. Because as I said earlier, there is a missing link between what ought to be the role of the judiciary and the judicial officers in relation to electoral processes. You find that they will obviously apply the strict letter of the law, but I would humbly submit that majority of our judicial officers are a little bit unfamiliar or ignorant, for lack of better words, of the core electoral processes, so that then they are unable to deliver justice as expected of them. So there is a need, therefore, I think, as part of the job that SADC Parliamentary Forum will be doing on the electoral, on the model law, to ensure that there is a conceptualization of a capacity building program to provide capacity to our judicial officers. I thank you, Chair. I hope I have dealt with the topic that was allocated to me, and I stand guided by the inputs going forward so that we can clarify some of the points.
Thank you. Thank you very much, Dr. Jale, for such a very clear presentation. The way you've done it, and the way you've gone through the model law has just been wonderful, and again showing us how the SADC region should really take things seriously. And if only we could do that, then definitely our region will serve as a model for the whole of Africa. Thank you very much again. I think we spot on time, and I'm sure Justice Din Gake will be very happy to note that we are spot on time. And so I would like to hand over to you as you address us on the Malawi Constitutional Court judgment on the 2019 presidential elections, commonly known as the TPEX elections, the lessons and implications for the SADC-PF election observation and domestication of the model law. Justice, over to you. The floor is yours.
Thank you, Chair. Can you hear me?
Yes, you very loud and clear, yes.
Thank you so much, and thank you for your very illuminating opening remarks. Permit me also to greet my colleagues. Many of them I haven't seen in a long time. The SG, among others, Victor Shale, one of the architects of the model law, SADC model law in elections. So, and many others, Kurasha, you, Chair, I see Hilda is there, and Moses, and many others. Greetings to all of you.
Thank you.
I think we meet at a momentous time, given the context in which we are discussing the issue of electoral justice. Dr. Shale has eloquently indicated the very heartbeat of the SADC model laws, which I do not need to repeat. But for context's sake, I emphasize the ingredients that he highlighted, starting with the rule of law, universal adult suffrage, equality before the law, and credible dispute resolution mechanisms. Those, in my mind, lie at the heart of the SADC model law on elections. And congratulations are due to you, the SADC PF, for coming up with such a model law that is meant to facilitate democratic elections. My watch says is 2:02 or thereabout. I've been given about 40 minutes. I will aim to deliver within 20 minutes so that we save some time for others to be able to engage with this topic. My presentation would hopefully take 20 minutes, as I say, and I'll start with the background and then give a very quick overview of the irregularities committed by the Electoral Commission in Malawi as per the findings of the Constitutional Court and affirmed by the Supreme Court. And thereafter, I'll move to the lessons that could be learned from the judgment. And fourthly, the implications of the judgment on the electoral observer missions in Africa. And then I'll conclude my presentation. But allow me, Chair, to begin with a very poignant and relevant quotation from one of the legal luminaries of our continent, and himself a judicial powerhouse. This quotation is critical as it implicates exactly what we are talking about. And this is by Willie Mutunga, the former Chief Justice of Kenya, when on the 14th of November 2011, he was addressing members of Kenya Electoral Commission. So if there are members of the Electoral Commission here, they can take note of these golden words by my brother and friend, Justice Willie Mutunga. He said the following: there is no higher crime an individual, an institution, or a group of people can commit than one that subverts the sovereign will of the people, whether through incompetence, negligence, or by design make the expression of that will inarticulate, close quotation. Now the Chief Justice says there can be no higher crime. There can be no higher crime. In February 2020, the Constitutional Court of Malawi, in a monumental 500-page judgment, annulled the country's 2019 presidential elections and ordered a rerun within 150 days, citing widespread irregularities that included the unlawful use of correction fluid, otherwise known, as the chair said, by the name the TPEX. I did not know, Chair, that is now called the TPEX election. I'll add it to my records. The court, the Constitutional Court, as affirmed by the Supreme Court, also found that about a quarter of the result sheets were verified and concluded that such conduct amounted to serious malpractice that undermined the integrity of the elections. On appeal, the Supreme Court of Malawi upheld the decision of the Constitutional Court, and consistent with the order of the court, elections were held a few weeks ago, and the incumbent president, Professor Mutharika, as we know, was defeated. So both the decision and the implementation of the orders of the court must count as a triumph for democracy in a continent where quite often the might of the sword triumphs the might of the pen. As a result of that decision, Malawi became the first country in Africa that an election rerun resulted in the defeat of an incumbent. The path towards the delivery of historic judgment included, as many of us will recall, extraordinary scenes beamed through our TVs in which judges escorted by the military came sporting bulletproof vests and jackets to deliver their judgment that would forever be etched in our memories as unprecedented and sweet in a continent in which the military has often sided with the ruling class than the wielders of sovereign power, being the people, when they were disenfranchised and their voices muffled due to grave electoral malpractice. My brother Potani J commenced in a preamble his monumental judgment, their monumental judgment, by saying the following, and this lies at the heart of the SADC model law on elections. He said he could as well have been quoting the SADC model law on elections. He said the following: credible, free and fair elections form a solid foundation to democracy. You yourself, Chair, remarked about this in your opening remarks in different ways, citing correctly that the integrity of the elections lie at the heart of any democratic dispensation. The opposition in Africa would testify to the fact that winning presidential elections or elections at all in Africa is like attempting to drive the camel through the eye of a needle, on account of a number of factors, top among which is the quantitative test and the ease with which our courts have embraced technicalities at the expense of substance. Malawi was perhaps the second country following Kenya to nullify presidential elections. In 2017, Kenya Supreme Court nullified the country's August 27 presidential elections and ordered a new vote after the opposition leader Raila Odinga and his party claimed that the electronic system was hacked and rigged in favor of the governing party. And as my brother Potani J, the lead judge in the Constitutional Court of Malawi, said, elections are an important pillar of democracy, and the right to vote is sacred and should not be taken lightly by anyone, let alone the Electoral Commission that is charged with facilitating that the voice of the people is heard. The duty to protect the vote and not to unduly disenfranchise the people is absolutely essential, and the courts must always, at all costs, protect this right. And they can only do so if they follow the logic and imperatives of the rule of law. Unfortunately, Africa has experienced a strong scorched earth culture, in which illicit money combined with electoral manipulation to undermine the sacred nature of the right to vote, in terms of which the people have now ceased to matter at all. Now, the AU and other sub-regional bodies and non-governmental organizations interested in democracy often send observer missions to observe the elections and report on their findings and make recommendations relative to the requirement that the elections must be free and fair and credible. In most cases, if not all, they have invariably returned a verdict consistent with the verdict of the Electoral Commission that the elections were free, fair, and credible. Now, following the Supreme Court decision in Kenya of 2017 and the Malawi decision of recent, a credibility crisis hangs over the heads of the electoral commissions that are sent to observe elections. Now, as Shale correctly pointed out, election disputes are inherent in every election. For many years in Africa, the dominant test that was used by the courts to decide whether to overturn elections was whether the margin achieved by the competitors was such that if you consider the irregularities, it would make any difference at all. That is called the quantitative test. This has been the test employed by most African judiciaries for as long as I can remember, from teaching constitutional law at the University of Botswana up to my days in the bench. The dominant test has always been the quantitative test. It is a test borrowed from the English case of Morgan versus Simpson of 1975. In that case, Simpson and others petitioned the courts alleging that there were certain irregularities that denied Simpson the victory that he thought was his. What had happened was that the electoral officers had not counted 44 ballot papers because they were not stamped. And the reason why they were not stamped was on account of the mistake by the electoral officers. So the winner won with a majority of 11. But had those 44 unstamped ballots been counted, the rival would have won by a margin of 7. So Simpson went to court and the divisional court dismissed his case, saying that the irregularities complained of were not substantial and could not have affected the results. On appeal, the Court of Appeal said, no, if you take into account the margin and the irregularity of leaving out 44 ballot papers, then definitely the irregularity would have affected the results. So that is the quantitative test. We saw the qualitative test that is concerned with the integrity of the elections, whether the elections were conducted in accordance with the law, whether they were free, fair, or credible, and not necessarily focusing on the numbers. We saw that test be implemented in Africa, probably for the first time in 2017 in Kenya. They employed the qualitative test that zooms on the question of the integrity of the elections. That was in the case of Raila Odinga and others versus the Independent Electoral Boundaries Commission. In Uganda, in the case of Winnie Babuhunga, Kibuka J said the following about the qualitative and the quantitative test. He said, the quantitative test is said to be more focused on numbers, but the qualitative test is more suitable where the quality of the entire electoral process is being interrogated and determined. In the case of Malawi, both the quantitative and qualitative tests were employed. But in my perusal of both judgments, I am of the firm view that the qualitative test had the upper hand, because the court zeroed on the irregularities that were committed. And it was the view of the Constitutional Court and the Supreme Court that the Electoral Commission appeared to have taken liberties on the requirement that they must strictly follow the dictates of the law. And that in conducting an election that is credible, they should not depart from the dictates of the law. But at the end of the day, both the Constitutional Court and the Supreme Court found that the Electoral Commission in Malawi had departed fundamentally from the dictates of the law. The law required that result tally sheets, once compiled at a polling station, must be mandatorily signed by the returning officer and polling staff. The court found that the Electoral Commission in tallying the national results, used tally sheets that had not been signed, among others. When these result tally sheets leave the polling station, they are supposed to be guarded against any form of tampering or interference. They are supposed to go to the district commissioner's office for a compilation, and thereafter to the National Tally Center. The Electoral Commission in Malawi, according to the court, ignored this. It also unprocedurally created constituency tally centers where massive alterations were made to the tally sheets that were not to be tampered with. The court found that some original tally sheets were inexplicably replaced with duplicate tally sheets, with the originals not being kept. So that was an avalanche of irregularities that the court found were committed by the Electoral Commission. The court also found that in some instances, improper tally sheets were used and were accepted by the Electoral Commission in compiling the national result. And all these was not permissible in terms of the law, meaning therefore that the Electoral Commission of Malawi did not conduct the elections in accordance with the law. There were also issues of verification that the court found unsatisfactory. At the National Tally Center, before compilation of national results, the EC, the Electoral Commission, was supposed to also resolve all outstanding disputes, but it left a huge number unattended. It also came to light that for those it claimed it had resolved, the Electoral Commission had largely abandoned its quasi-judicial functions by delegating the task to the Chief Elections Officer, which was not permissible in terms of the law. And then the Electoral Commission then proceeded to announce the national results before fully complying with the condition precedent to announcement, meaning, again, they failed to comply with the law. And they even signed the national result. They even signed the national result after they had already declared the result, which the court found impermissible. So the Constitutional Court found the violations had been grave and a clear demonstration that the Electoral Commission's incompetence, the elections could not have been said to be free, fair, and credible, and annulled them. So that is a summary of the reasoning of the court, of which I am in respectful agreement. The judgment, in my mind, is both a triumph for the rule of law and for democracy. It is, in my mind, a masterstroke of pure brilliance in terms of the constitutional reasoning adopted, and if it were possible, it would be made an annex to the Malawi Constitution and made compulsory reading for all constitutional law students in Malawi and in Africa. You see, for all this to happen, in my mind, you need an enabling legal framework. Some constitutions and electoral laws are still archaic and does not aid the judges to deliver what my friend Victor calls electoral justice. So if you have deficient constitution, deficient electoral laws, then you cannot hope for electoral justice. Fortunately, in the case of Malawi, the Malawi 1994 constitution, as subsequently amended, expanded the democratic space and reinforced the powers of the courts to be able to deliver justice in the manner they have done. Now, electoral disputes lie at the intersection of law and politics, and the time has come for the justices of our region to accept that they have become institutional political actors in order to ensure that electoral justice is done. And again, before I end, I again derive inspiration from the sentiments of my brother and friend, Justice Willie Mutunga, who said the following about the determination of electoral disputes. He said, and the faithful and fair determination of election disputes requires judicial courage from the bench, courage and integrity, grounded on the oath of office that should see the courts not being partisan, taking into account the interests of the executive, the corporate sector, civil society, international actors, or the media, but simply being impartial and loyal to the law. What then are the lessons from Malawi? Is my next sub-theme. The lessons coming from Malawi are that elections are an important pillar of democracy, as you have expressed, Mr. Chair, and as my friend Victor has said. But that is not enough. You also need an independent, fearless, and courageous judiciary. I will also add, you also need a competent and knowledgeable judiciary. Because without knowledge, we can easily fall into a phase I call judicial adventurism, judgment without wisdom, judgment without knowledge, judgment not anchored on rationality, judgment not anchored on evidence, judgment not anchored on law. That is not justice, it's judicial adventurism. The other lesson is that you need a credible electoral commission. In the case of Malawi, when the rerun was ordered, a new chair came to chair the electoral commission. Again, my dear friend and brother, Justice Kachale, who came with the credentials of impartiality and independence, coming from the bench to steer the ship towards a credible elections, which he delivered. What then are the implications of the judgment on election observer missions if we take into account the case of Malawi? Going through the judgment, I did not see the part on what the observer mission said featuring in any manner that could have been decisive to determine the verdict of the court. But in the case of Raila Odinga that I mentioned earlier, there was a commentary that is critical on the observer electoral bodies. At paragraph 302 of the Raila case, the court said, we must also state that whereas the role of observers and their interim reports were heavily relied upon by the respondents to demonstrate that the elections were free and fair, the evidence before us points to the fact that hardly any of the observers interrogated the process beyond simply counting and tallying at the polling stations. The interim reports cannot therefore be used to authenticate the transmission and eventual declaration of result, close quote. So you see from the Raila Odinga case there that the court did not think much about the input of the observer mission. It is a sad reality of our times that quite often observers in Africa appear too quick to endorse the elections as free and fair. We must start interrogating how these observer missions are appointed. Who are they? Do they have any pedigree or track record of impartiality and independence? Do they have? Because if they don't have, we are undermining the integrity of the elections. We should only send to the field people with demonstrated pedigree of independence and impartiality, which has been lacking in our missions. So we now need a situation where professional bodies must be sent to observe elections. Professional bodies like Africa Judges and Jurists Forum may be some of the credible entities that may go and to observe elections. I conclude, Chair, with the following remarks, that the Supreme Court of Kenya in 2017 and the Malawi Constitutional Court and the Supreme Court, constitutional reasoning is so aligned as to give hope that going forward, Africa may now see a situation in which a truly independent judiciary sides with justice. An abundance embracing technicality or being obsessed with the quantitative test as compared to the qualitative test. If you allow me, in the interest of time so that everyone can comment, I rest my presentation this far, and I thank you for your patience, Chair, and the other members. Thank you very much.
Thank you very much, Justice Dingake. I think the presentation really highlighted the importance of having strong institutions. And I personally like the way you talked about the judiciary having an impartial and independent judiciary, but at the same time, the other main institution, which is the Electoral Commission, because they are the ones who really ensure that the game is being played fairly. But then the observer missions. I guess a lot of us will have something to say on observer missions, and I can only say here in Seychelles we did observe that some of those people who came were more interested in the sun and sea instead of finding out what was really happening. But okay, we've had the two presentations. Now, basically, the floor is open. And Kurasha, you have to help me there because I don't know how to go about this to see who's got a hand raised, and so you will have to guide me there. But the floor is open for your comments, for your remarks and suggestions as to how the SADC region and of course Africa can move forward as far as elections are concerned.
Thank you, Chair. What I was going to propose, particularly to the other participants, if you are able to type in your question under the chat, please go ahead and do so, because in doing so, the presenters will be able to see the questions. You may even indicate to whom are you directing your question. As we do that, if there are any honorable members who wish to take the floor, they may as well indicate orally to the chair, and the chair will recognize them and they will be able to respond, I mean, to ask their questions.
Thank you. From South Africa.
Yes, Darren, go ahead. Okay, Darren, Honorable Bergman, go ahead.
Chair, thank you very much. To the Chief Justice, and mine's more a statement than a question. I think we've definitely seen the importance of the judiciary. And, you know, when we talk about the independence of the judiciary and the legislature and the executive, I think when we look at SADC and we look at all the different countries that make up SADC, it's not that all the countries are necessarily far behind each other, but it is that there's almost a roadmap to get to a point that we can say that we're at the role model. And I think I said it at the last meeting that the role model law is a roadmap. It's not, it's almost a point that we all get to. and that when we're trying to bring all the countries into the same point, that how we sell it is by the fact that we're not just going to work on the politicians, we're also going to work on the judiciary. We also have to work in the legislature and say that when we make our laws, that our laws are going to do exactly the same thing. But I think with the Chief Justice, with the Justice, when you look at the success of the Malawi elections, it was actually that not only was the court able to stand up to the government, but it was also, as the Justice says, it was that they were actually able to implement that election without fear of doing so. Different to in Kenya, where Kenya there was still a possibility that something might, that there was still a fear. There was no watchdog to watch over the intimidation or to watch over that there might still be control over the election or the mechanisms of how those elections were held. In Malawi, the elections were free and fair the second time around. In Kenya, there was still a question, and that's where Prime Minister Odinga, where he's threatening to pull out and pulled out, was around the free and fairness of the elections, but there was no watchdog to actually oversee that, and the court's overstep was limited at that point. And maybe this is where on our role model is that the court should maybe have the power, or as Dr. Shale was saying, is maybe the IEC, the Electoral Commission, has to ensure that what the court says is implemented, and if it's not implemented, that there's some recourse, that there's a breach of, that there's a contempt of court that the Electoral Commission then faces. Now, in terms of observer missions, I think SADC fell short in the last 2 years in observer missions, although the African Union and some parliaments were able to partake in the observer missions. And as we see now, they really were a farce. But I know that it was mentioned at the last SADC meeting, is when do you begin the observer mission? Because in earnest, elections are really, if they are stolen, they're not stolen at the polls. The elections could be stolen at the start of the election campaign. It's when you start demarcating your constituencies. It could be when you start creating the constitution. It could be at any time way before when the election campaign itself starts. It's when you're creating the rules and regulations. So when do we actually start the election observation mission? And what do you actually start looking for in itself? And I think that's our challenge, is when we create the election observation mission, the time last time was actually our duration, is how long can we spend on it, and how long after do you stay there to ensure that the ballot counting was fair, the objection period was fair. And I think these are the challenges that we'll be left with, probably more questions than answers. Thank you very much.
Yeah, that's right. Thank you. Thank you. Okay, go ahead, Kurasha.
Chair, there are a few questions. I could read them out.
Yes.
The first one I see is from the person who is speaking now, and it says, in view of the qualitative versus quantitative test, and against the traditional inclination towards qualitative bias being embedded in the current election observation methodology, do you see election observation missions as still relevant and a worth investment? For instance, preliminary reports are often issued within 4 days after voting, when results management processes will be in full swing. If yes, that is, if election observation missions are still a relevant investment, how can the current election observation methodology be improved to remain relevant, especially in view of what we have witnessed in Kenya in 2017 and Malawi in 2020? I guess this question is primarily directed to Judge Tingake. Then the other one is a comment from Yeruda from ECF SADC. He says, thank you, Kurasha, for the question. It is evident from the Malawi case that we need to reflect more on the quality and impact on election observation. In addition, with reference to the duration of missions and the electoral instruments used. There's also another question from Dr. Dane from GIZ. Justice Dingake, thank you very much. My question, in the absence of objective measures on qualitative tests, how do you assess the degree of qualitative irregularities on the outcome? Say, access to media, freedom of assembly, campaign, etc. The last question in this role, Chair, says, what role should bodies like ECF, SADC, Commonwealth, etc. perform in the instituting a paradigm shift from keeping the peace by just endorsing the country's election, will capacity building by a key activity in facilitating observation missions? This is a question for Judge Dingake. My proposal, Chair, is that we can have those questions for now, and then after the response, you may take questions from the members, then I'll also add the ones that are from the participants.
Yeah, maybe just before, there is another question that we could add, and this is from Chabalala saying, what would be the recommendation for addressing / mitigating the influence of partisan affiliations or lack of objectivity during proceedings of electoral justice by the preceding judiciary? So may I propose that Justice Dingake starts and then Dr. Shale continues. Our time is not, we don't have that much time. So maybe 5 minutes, 5 minutes each. Go ahead, Justice.
Thank you, Chair. I apologize in advance if I missed some, and an order is hereby issued, directed at Shale, that he shall without fail answer all the questions that I have omitted to answer without default whatsoever. Now, there was an earlier comment, I think my friend from South Africa, I think it was a comment, but I just wanted to say that, highlight what I had earlier said, that the fact that in Malawi, the court issued an order that was obeyed is a triumph for democracy. In other regions or places, the executive would have done everything in its power to frustrate the implementation of the order, including that there are no funds to run elections or some other reason. So we must still congratulate the executive that has now left office and other players for ensuring that court orders are obeyed. And as we say, the rule of law requires exactly that. Court orders are not negotiable. They are to be obeyed by everyone. Now, Kurasha fired a number of questions to me about the qualitative test and the worthiness of election observer missions. Well, let me say that in my view, we still need them, because it does not follow that at all times the courts would always be on the correct path. It doesn't follow that any entity at any given time will always be on the correct path. A situation may arise where the courts behave like discredited electoral commissions. So you need more hands on the deck to watch over the entire process. So I would say that subject to them improving their methodology and sending the requisite personnel and going there in time, because the election is not an event, it's a process. And when we speak of free and fair and credible elections, we don't mean on the election day. we mean all the stages of the electoral process must be observed, including fair media coverage, including a level playing field. They must develop a solid criteria and they must go there in time, not 2 weeks before time, insufficient time. So that methodology must be improved because, as I said, the elections are not an event. And Hilda is correct that we need to seriously now reflect on what is the best way going forward. Let us see the next observer election mission in Africa being different. Let us see some verifiable criteria. Let all those who are stand to scrutiny, not holiday makers. They must stand to scrutiny. They must have verifiable pedigree of independence and credibility and knowledge to detect anything that is going wrong. You don't send someone who may not have the requisite knowledge to be able to pick what is wrong. You don't send Judge Dingake to go and inquire on the mechanics of a car when Judge Dingake has no clue about that process. So we need to send the right people. Now, someone sent a very an interesting question about, in the absence of objective tests, how do we assess the requisite threshold needed in a qualitative approach? I think I like the gentleman who asked this question. And I needed a few days and weeks to tell him why I like him so much. It is because I think for the legal fraternity and the judges, they need to thresh out this particular question. I have personally posted at several forums of judges to say to them that we need to develop a clear threshold, absence the objective criteria, because otherwise we can have a situation where subjective judgments are substituted for objectivity. And that we don't want to happen. So we need the judges across the world in Africa, they need to develop this further. It's a good approach, but it's intellectually underdeveloped in my view, in terms of exactly what the question that was posed. I once asked one judge in Entebbe in Malawi the question that this qualitative test is problematic because what happens in a situation where an incumbent sends the police to block a roadblock that has 5 buses coming from a stronghold of the opponent, and the police play tricks and to detain them, and once polling station is closed, they release them. That would impact on the qualitative test. But are we going to annul the elections on that basis alone? That is why I say this question actually needs to be interrogated further. And maybe Kurasha and others, Hilda and many others, would help us come and discuss and develop this particular pathway. And that is all I remember from the questions. I think the burden that now remains, unfortunately, is on Shale. Remembering that I said court orders are non-negotiable, he would answer without fail.
Thank you very much, Justice. Dr. Shale, over to you.
Thank you, Chair. I'm not even sure actually if there's any more questions to answer, because I think Honorable Justice Dingake has already, I think, dealt with most of the questions, even touching on some of the comments. You see, I have attempted to basically throw petrol in your question, Mr. Kurasha, because I think we have a problem that, for instance, since the pandemic this year, almost all of us are having to spend endless hours on webinars holding different dialogues. But you see, not all these webinars serve any meaningful purpose. Some of the webinars are just boxes to tick that we too also organized a webinar. Others are held and they actually deliver certain results. I'm saying this because there is also now a lot of questions around the efficacy of election observation. But I can bet that also the motives behind those questions are also many and varied.
Sure.
Whether or not we have or whether or not we observe election, in my view, should not even be a question.
Mm-hmm.
The problem in our region and on our continent is who is observing, who is being observed, why is observation being done, who is financing the observation. Just like we have to ask who is financing our elections. In my view, if we observe elections because there's something that we are looking to get out of that. So in other words, that's why on the chat page there, I've referred to the political economy of election observation. The motives of the, for instance, democracy support groups have to be questioned. We need to be clear. If we go to observe elections in Zimbabwe and we already have the outcome in mind, there's no point. We may as well observe on the internet as we did on Malawi. But of course, Honorable Chairperson, I would still like to come and observe elections in Seychelles.
You're most welcome. Most welcome.
Yeah, so the point I'm saying to that question, Mr. Gurasha, is whether it is quantitative or qualitative methodologies, those need to be perfected, and we have to tell the truth. The problem is people see something white and they say, oh, everything was pink in that election. Because they either already came with the conclusion that things are pink in that election, or they were told, I mean, I have had the privilege to participate in different election observation missions. The discussion just on the statements that you were talking about, how to craft a statement and why certain things can be said, is shocking. So if election observation was to die, it will not die because of its irrelevance. It will die because it does not meet the expectations of those who finance it.
Mm-hmm.
My answer to that question.
Thank you, Dr. Shale. But of course, we in the SADC region, we've sort of let down our member states because we haven't really participated in observer missions lately, and this in itself has in a sense prevented us as an organization from getting the experience, and I think this is one area. And we've talked about that many a time. This is one area which we need to take seriously, because it's only through the experience that and through reports that are properly written that we can improve. But unfortunately, of late we haven't been present. And when you think of the elections in Botswana, where there were problems, elections in Namibia, and then of course Malawi. 3 countries, 3 member states where SADC was just not present. SADC PF was not present. There are things also that we need to do to improve on what we are talking about. Because if we want to set high standards, we should lead by example and not just depend on the book, because it's what we have to move. Who would like to? Anybody wants to?
Yes, I mean.
Vice Chair? Chair?
Yes.
The Vice Chair is asking
Yes,
for him.
Josefina.
Sim, sim. Muito obrigada, Presidente. Vou falar em português, acho que o tradutor está por aí. Estará? Posso continuar? Não.
Yes, go ahead.
Ok.
Go ahead, Josefina.
Não,
Yes.
eu quero primeiro, naturalmente, agradecer, portanto, não só a intervenção do Presidente, como também dos 2 preletores. O Dr. Vítor já nos habituou às suas preleções, que de facto são sempre muito positivas. Em relação à apresentação do Dr. Vítor, a questão que eu tenho em mente é que nós precisamos efetivamente de trabalhar na divulgação da lei modelo com vista à sua implementação. E, sobretudo, termos em conta os calendários eleitorais da nossa região para podermos começar a trabalhar atempadamente com o tempo que, de facto, a observação e o acompanhamento eleitoral exige. Portanto, agradecer uma vez mais a intervenção, mas precisamos de fazer o texto. O texto, primeiro, divulgação, os nossos parlamentos nacionais, os nossos estados, a sociedade civil, os partidos políticos, as instituições do executivo precisam efetivamente de conhecer a lei eleitoral. E, de facto, esta é uma atividade que nós pensamos que a nossa comissão deve continuar a realizar. Já se falou sobre isso no passado. Em relação à intervenção do juiz Dengake, eu começaria primeiro por felicitar o Malawi. Efetivamente, é desse tipo de justiça, de sistema judiciário que nós precisamos. Isto dá-nos a ideia de que, efetivamente, uma crise eleitoral não precisa de nos conduzir necessariamente a uma crise violenta, não é? Dá-nos, portanto, a indicação de que os nossos sistemas judiciais e de justiça eleitoral podem ser credíveis. Eu queria secundar a proposta que fez o juiz Dengake em relação, digamos, à constituição dos corpos, portanto, das missões eleitorais com corpos profissionais. Alguns, portanto, os juízes fazerem parte das delegações dos países em termos de constituição de delegações eleitorais. Mas também poria ênfase na ausência, sobretudo no caso do Malawi, a ausência portanto, da missão do Fórum Parlamentar da SADC, o nosso presidente já falou. Nunca é demais falarmos sobre isso. A minha preocupação, fundamentalmente em relação a esta questão, é que nós não podemos continuar a depender de apoios de fora para realizar os nossos assuntos e assuntos as nossas missões tão importantes. Quero dizer que os nossos países, não é? Os nossos executivos, os nossos parlamentos nacionais têm que se bater em relação à questão do financiamento das missões eleitorais. Podemos, sim senhora, contar, já vimos que os nossos parceiros internacionais não estão tão disponíveis para o financiamento dessas missões. o que aconteceu no Malawi foi um caso evidente de que, bom, quem sabe se pelo menos, não sei que outros observadores lá estiveram, mas se pelo menos o fórum lá tivesse estado presente, talvez tivesse suscitado algumas preocupações. Por conseguinte, acho que o fórum precisa de retomar as missões eleitorais de uma forma sustentável, devidamente financiadas, desejavelmente também pelos seus próprios governos, pelos seus próprios parlamentos por via dos governos. Essa é a contribuição que eu gostava de dar à nossa discussão. Muito obrigada, Presidente.
Thank you very much, Josefina. I think you've definitely raised some pertinent points, but let me, Justice or Dr. Shale, who would like to respond to the comments of the Vice Chair? Justice, maybe you could start.
On account of language barrier, Chair, I didn't follow. I could only pick my name being mentioned.
Oh, you didn't go down to tick on the translation. Because,
oh yes, I didn't. I see there is. I'm sorry. I missed that part.
Okay.
Yeah.
Be unfair. If there is a question, can someone just interpret quickly?
Yeah.
If there was a question for me or there was not?
No, there wasn't a question, but a general comment on.
Yeah.
Maybe Dr. Shale should.
Yes.
Could.
No, thank you, Chair. I think I would. I really concur with the input by Honorable Diakite.
Mm-hmm.
I think for SADC Parliamentary Forum, the momentum has to be maintained. That is ensuring that the model law is taken forward. That because, as we said, for instance, going back to the question around election observation, indeed, both the SADC principles and the SADC model law speak to the need for a long-term observation. Because indeed, as Honorable Justice Dingake was saying, it's difficult to observe election within a short period of time. It's regrettable that SADC Parliament has not been able to observe all elections, and we all know we are financially constrained, but we really hope that a way out of this can be found, because it is quite important to strike the iron whilst it's still hot. Because part of observation is not only pre-election, as the case has been shortly around the elections, but it is also by way of following up the SADC guidelines and indeed the model law to ensure that the SADC Parliamentary Forum uses its influence and its unique position to influence reforms within the member parliament. That for me is part of the observation, because then you prevent, that's what we call a conflict prevention. So the implementation of the SADC model law will definitely address all these issues that we have been grappling with, and we hope that member parliaments can avail resources for this, vision to really continue. So yes, there's a need for long-term observation, and organizations like SADC Parliament must be able to observe elections in all the SADC member states, depending on resources Maybe you have smaller, missions, technical missions, not necessarily a full, complement, as has been the case. My earlier intervention was really trying to say we need to strike a balance between the so-called foreign observers and local observers, foreign here being outside of the continent largely. Because the trend, and truth be told, is that those have been more vocal than the locals. So, but even for the locals, I have said as a challenge that we must observe and state what we have observed instead of, sanitizing, to use the topical word now, instead of sanitizing the truth, because this again, Chair, is not necessarily the problem of a SADC Parliamentary Forum. But the more these intergovernmental organizations sanitize the truth, the more it's going to be difficult even for SADC Parliament to see the implementation of the SADC model law and to support the SADC principles. Because for somebody sitting out there, they hear SADC and then they say, well, these people are the same. So it is important, as Justice Dingake was saying, that people need to be objective if they are to deliver peace and prosperity to our region.
Wonderful, perfect. I like the way you've summarized the role of such of these observer missions. I see Honorable Indi Weni from Zimbabwe. You'd like to share with us?
Thank you very much, Mr. Chairman. And my question really was on the two key institutions, that is the electoral body and the courts. In order to deliver electoral justice, how then should we ensure their impartiality? Because there was mention of these institutions being captured in some countries. How does the SADC PF ensure that these two institutions are impartial so as to deliver final electoral justice?
Justice Dingake, I think this one is straight in your court.
Thank you, Chair. Can you hear me?
Yes, we can. Yeah.
Yes, I was saying thank you for the question. It's not an easy question because if you look into the legal framework governing the independent electoral commissions in Africa, you'll find that the law is very uneven. Some countries are very clear and explicit in terms of guaranteeing the independence of the electoral commissions. In some countries, the electoral commissions in practice are more independent than others in Africa. So I would say as a lawyer that for me, what is important is that you must at least ensure that so far as the law is concerned, the independence is clearly guaranteed. As far, that is the very minimum, because whether that will translate into practice is another question. But we need to review our laws and to make it clear that the independent electoral commissions are truly independent. Currently, the only thing they share, these electoral commissions in Africa, is the appellation independent. The appellation independent. But beyond that, some have, in real practice, made the appellation independent laughable. So we need to guarantee at the minimum in law the independence in the clearest of terms. And maybe that is what the SADC PF Secretary General and Kurasha, in order to give effect to the SADC model law, we have to attend to the very minimal that we require. Most modern constitutions say the following of the judiciaries. They said the judiciary shall be independent of any entity and not accountable to anyone, and they shall have the power to declare anything inconsistent with the Constitution invalid. So that is clear, isn't it? The powers are very clear. The challenge then is whether the people you bring, you see, Chair, there is the law and there's also the people.
Yeah, you're right.
You may bring, those who live in South Africa may give a case study of the Ombudsman, the Office of the Public Protector in South Africa. They may well tell you tales about how nothing has changed in law, but how the personalities performed.
Yeah.
So you need the personalities too that match the constitutional powers of independence. I highlighted what happened with the rerun with Kachalia being brought into the picture, and he really did assert his independence. And so far, one hasn't had many other fundamental complaints. So there is the law, there is also the personnel. And that applies to both the Electoral Commission and the judiciary. But of course, there is also civil society, the citizenry. The citizenry plays a big role in ensuring that none of us is derailed, because even the judges can be derailed. No one is infallible. But we need at least also outside these structures an informed, active citizenry to say no, not in our name.
Thank you very much, Justice. You remind me of the police service without favor or fear, but
Yes.
then it goes back to the personnel, as you rightly say. I'm looking at my time. We are 10 minutes over the scheduled time, and may I ask Kurasha for some guidance? Kurasha, are you there?
Yes, Chair. So the guidance, Chair, is that for the convenience of everyone, it is good for and consistent with democracy and governance for the committee to adjourn now. And then we meet tomorrow in terms of our program, Chair, at 9:30.
Yes. Okay. Thank you very much, Kurasha. And I'd like to thank everyone for the very active participation. But in particular, I would like to thank our two resource persons, Justice Dingake and Dr. Shale. I think the two presentations were great, and members are in fact asking for copies of that presentation. But I could see that you only had notes, but if it is at all possible for us to have copies of the two presentations, I think it would definitely help, and parliaments and governments to need to know what we've been talking about, because it involves them, and especially where it concerns the election missions, observer missions, because parliaments, governments need to put in the money in order for these to happen. But then, of course, even though we're talking about the judiciary, we hope that through the model law that that we've worked on, that we had a first session in Zimbabwe where we started unpacking it. I think if all our countries, all our member states can really adopt the whole process as indicated in the model law, then I think we will all be making a giant step forward. So once again, thank you very much, everybody, for your participation, and have a good evening, and we'll meet tomorrow morning. So, kwaheri, goodbye, au revoir, everything.